what is a downside to a side hustle stroke moonlighting, conflict of interest and law? As you know, guys, currently the economy is so bad that even people who currently have any employment find themselves doing side hustles, or what is called moonlighting in terms of the labor law. So do you guys know what is the downside? What are the dangers of a side hustle or moonlighting leading to a conflict of interest in terms of the law and the law? Okay? So employees are required to devote their time, effort, and skills to advance their employer's business interests. It is considered a breach of good faith when employees pursue and obtain additional work from other employers, which might diminish their employer's profitability, right? The current economic climate has caused many employees to seek additional sources of income to supplement their primary source of income. With the rise of the side hustle culture, okay, or moonlighting, employers must take additional measures to prevent conflicts of interest and safeguard their businesses. Greetings, guys. Welcome to the platform. My name is Tibos Kosana. The name of the platform is Izwi Labansund, the voice for Africans. Okay, so let's take one case here. In Vilakazi versus Commission for Conciliation, Mediation and Arbitration, CCMA, and others, 3rd of November 2023, the Labour Court considered the issue of moonlighting as a form of conflict interest. What are the facts around this country, around this case? The employee was initially employed as a part-time lecturer by the University of Witwatersrand, right, which is university in this case is Wits, right, and also by Alexander Forbes. In 2017, the employee resigned from Alexander Forbes pursuant to her full-time employment as a lecturer at the university in 2018. The employee was required, right, to acquaint herself with the policies, rules, and regulations applicable to her full-time employment with the university, in particular the university's policy on the declaration of interest and the provisions pertaining to conflicts of interest and moonlighting. The policy defines moonlighting as such, quote, taking up additional employment which may require time, investment that may impede a staff member in meeting his or her contractual obligation to the university, close quote. In terms of the policy, an employee is required to approach the Vice Chancellor's office for approval of any external institutional affairs, including moonlighting. The university was alive to the fact that many of its full-time employees were pursuing additional employment, which could result in a conflict with its interests. It implemented policies and regulations to manage the adverse impact of any conflict of interest, Importantly, the university did not prohibit moonlighting in the policy. Instead, it requires that an employee who wishes to take up additional employment declare such interest to the office of the Vice Chancellor before accepting and commencing with such additional employment. The office of the Vice Chancellor will evaluate the terms of additional employment in light of its own operational requirements and make an informed decision as to whether the additional employment was permissible or not. However, shortly after taking up full-time employment with the university, the employee committed herself to an additional full-time job with a third-party employer. The employee failed to disclose her external employment to the office of the Vice Chancellor and to obtain permission to pursue this external employment whilst in the full-time employ of the university. When the employee's additional employment was discovered by her supervisor, she was charged with and found guilty of gross misconduct. The employee argued that she could manage both full-time positions and that she saw no conflict of interest. The employee was dismissed and subsequently referred an unfair dismissal dispute to the Commission for Conciliation, Mediation and Arbitration. The matter remained unresolved at the conciliation and proceeded to arbitration, where it was found that the employee's dismissal was both procedurally and substantively fair. The employee, dissatisfied with the arbitration award, approached the Labour Court to review and set aside the Commissioner's arbitration award. Then the Labour Court finding: it was common cause that the employee engaged in moonlighting in breach of the policy and her fiduciary duties. The Labour Court dismissed the employee's review application and held that her dismissal was both procedurally and substantively fair. The court found that the two full-time contractual relationships were mutually incompatible and could not practically exist together. The Labour Court reiterated that the contract of employment is one of the uberimerit fidei of the utmost good faith, and that employees owe their employers a fiduciary duty not to work against its interest. The employment relationship is rooted in the values of trust and confidence. A breach of good faith taints the relationship between an employer and an employee to such an extent that dismissal is justifiable and only appropriate outcome. Whether a conflict of interest in the form of moonlighting has occurred is not a subjective decision to be reached by an employee. It is the sole prerogative of an employer to regulate when moonlighting may be permitted, and if so, and on what terms. A disclosure after the fact is moot, and that the employer was robbed of the opportunity to apply its mind to the employee's intended additional employment and assess the risk and overall impact of a conflict of interest. A post facto disclosure accordingly cannot remedy the employee's failure to disclose additional employment. Importance of this case: the Labour Court has confirmed its view that moonlighting without disclosing same is unacceptable. Even in the absence of a clause in the employment contract or a policy provision, employees are seen to violate their fiduciary duty of good faith towards the employer by taking up additional employment without disclosing same to their employer. Pursuing additional full-time employment requires prior permission and upfront disclosure. Furthermore, it is not for an employee to subjectively determine the existence of a conflict of interest. In addition to general conflict of interest and disclosure clauses contained in an employment contract, employers are advisable to regulate moonlighting and safeguard their businesses by implementing appropriate policies and rules. Thank you guys for tuning in. Please remember to like, share, comment, subscribe, and join to become a paying member. Thank you very much.